great. So my name is Frank Lucido. I'm a family practice doctor in Berkeley since 1979. Since 1996, I've been performing medical cannabis evaluations. And early on, there were very few doctors doing that, so I was investigated by the medical board early on when 12 of the 20 most outspoken doctors were being investigated. So I started going right to the medical board at the public comment period, testifying about doctors being inappropriately investigated, and then they finally backed off of investigating all the doctors, which of course opened up the floodgates to some of the clowns that are doing it now. But ultimately, better access is ultimately going to be better for patients, which is one of the reasons I'm also one of the co-proponents of the Repeal Cannabis Prohibition Act of 2012, because really nobody should go to jail for marijuana offenses. And it shouldn't take a doctor's recommendation for an adult to decide whether to use marijuana, whether it's medicinal or not. So one of the things I wrote and put on my blog is the implementation of the Compassionate Use Act in a family medical practice. I want everybody that wants one of these to give one to your doctor. I want more doctors to feel comfortable making safe, appropriate recommendations, and I'll pass them out later or you can come get them. But one of my biggest disappointments is I wanted more doctors to feel comfortable in making safe and recommendations. And to this date, doctors are still afraid to make recommendations because they either don't know the law or they're afraid of the medical board. And you know, it's really disturbing because doctors are the only ones protected federally. Doctors are protected by the Kana decision, which went up to the appellate court. And so doctors are protected in making the recommendation, even federally, as long as they don't aid and abet a patient in obtaining cannabis. Patients are still, unfortunately, are still illegal based on the Raich decision. One of the few patients I can talk about is Angel Raich. She went to the Supreme Court. She lost her case, but it was not unanimous. It was 6-3. And I write my blog called The Victory of Raich because I make the case that even though she lost her case, not only was it not unanimous, but the federal government's own attorney was forced to say that it's unlikely we would go after individuals. And then one of my other heroes, Jeff Jones, the Oakland Cannabis Buyers Cooperative, made it to the Supreme Court. He lost his case, and that proved that the federal government can go after dispensaries. So right now we have doctors being the only ones protected federally, patients having this relative protection, and dispensaries having none federally. And then within the state, you've got all the different states have something somewhat different. So one of the real benefits of the Repeal Prohibition Act of 2012, we just passed our deadline 2 days ago. We're not going to get on the ballot in 2012, but we're going to go for 2014. And the beauty is we can't make something illegal. We can't make an illegal product legal because of federal law. They can come in and preempt it. But we can make it not illegal. We can repeal prohibition within the state like the state of New York did in 1923. They repealed alcohol prohibition a full 10 years before the federal government did. And for the last 10 years, the federal government had to do all its own enforcement. The governor of New York said, I'm not spending a postage stamp on prohibition. Unfortunately, for us, we've had prohibition of cannabis for like 70 years. They only had it for 3 years at that time, so even the police knew that it was ridiculous. Here you've got 2 or 3 generations of cops that still think it's illegal, even for patients, because they think that this is a technicality. So repealing prohibition is going to be the best thing we can do. I was at the rally in front of the federal building, and it was good. Some of my heroes were there. Richard Lee was there, and that just shows what a crime the federal government is committing, because he's one of the heroes of the movement. When Richard had to close down Oakster Dam, or at least turn it over to somebody else, I thought that was sad, but as he points out, his work is done. I went to the Michigan Medical Marijuana Expo 4 years ago, and I told Richard in one of my blogs, I said, if imitation is the sincerest form of flattery, you'll be happy to know there's at least 2 other cannabis colleges in Michigan and at least 2 other people demonstrating small grow operations for patients. So the information is out there. So the federal government cannot really stop it. They can hurt individuals, they can hurt the growers, but they can't really ultimately stop the movement. It's going to continue. So with the RCPA, our main points of the RCPA, repeal cannabis prohibition, is to repeal all criminal laws for adults 19 and over. And we chose 19 because It keeps it out of high school, but still sends the message that it's safer than alcohol. It mandates strict rules against contributing to the delinquency of minors by giving to minors and driving impaired. But our impaired standards are nothing to do with a blood test. Blood tests do not prove impairment. We define impairment by the jury instructions that juries are given in DUI cases, being unable to drive with the care and caution of a sober person. So it's a real test, because you can't be impaired no matter what. You can't be impaired and drive, whether it's from lack of sleep, whether it's mental illness, whether it's a legal drug. You should not be driving. But a per se test of cannabis should not keep you from driving, and blood tests do not prove that you're impaired when it comes to cannabis. The third thing it does is maintain patients' rights. This is our repeal cannabis prohibition. It maintains all the patient rights under Prop 215 and Senate Bill 420. And then it vests the California Cannabis Commission with the job of coming up with regulation of commercial amounts above 3 pounds. None of this 1 ounce thing. 3 pounds is reasonable, because if you can brew your own beer, they don't say you can brew a 6-pack or a case. They say you can brew 100 gallons. So 3 pounds is reasonable for personal use. If you're selling it, it's a different story. But it doesn't get regulated until 3 pounds or more. So really, it's a good safe haven for the mom and pops. And I just want to give a shout out to my heroes, Chris and Mickey, who I met before Prop 215, Stevie D'Angelo, Richard Lee, who've been stalwarts in this movement, and of course, Jack Hare, Todd Micaria, some of my heroes that have passed on, and of course, Dennis Perone. And again, I want you all to pick up a copy of the Implementation of the Compassionate Use Act in a Family Medical Practice. I'll be passing it out. It has my contact information, but I want you to give it to your doctors or any doctors that you know, because I want more doctors to feel comfortable making safe, appropriate recommendations, so that this doesn't get lampooned as a joke, because really people do need the medicine, and right now we do have medical, and hopefully eventually we'll have repeal of all criminal prohibitions against marijuana. Thank you.